Good afternoon, everyone. My name is Jakub Jaraczewski. I am a research coordinator at Democracy Reporting International, and I have the pleasure to welcome you all to the DRI and European Implementation Network launch webinar of the report Justice Delayed and Justice Denied on implementation of European Court judgments and the rule of law 2020 third edition. This is a sequel to our last year's report, which has been prepared by both organizations jointly. We will be sharing the link to the report in the chat during the event. This report is part of the Reconstitution Program, which is run by Democracy Reporting International and has been prepared with support from Stiftung Mercator, a German foundation, which is supporting both our organizations and our work on the rule of law. So once again, I have the pleasure to welcome you to our webinar. And let me first outline the structure of our meeting today. We will begin with presentation by two co-authors of our report, Ioana Ilescu, Law and Advocacy Officer at European Implementation Network. Ioana is working on monitoring the implementations of the judgments of the European Court of Human Rights and is collaborating with a network of partners organizations across Europe. One important point here is that our report focuses on the 27 EU member states, but the European Implementation Network works on the implementation of the European Court of Human Rights judgments across the whole Europe, all the Council of Europe member states. And the second co-author, Dr. Nina Tsereteli, research officer at Democracy Reporting International, an expert on judiciary, focusing on her research on courts and judges in Western Europe and working on several key initiatives and outputs of DRI, including today's report, but also the rule of law frequently asked question cards, which we will be releasing next week, and the upcoming map of judiciary in Europe. And following the presentations of our two co-authors, which will outline the report, the key takeaways and recommendations, we will turn to our esteemed guests who have joined us today. First, we will invite to speak Ms. Ambassador Vesna Kos, Head of Delegation of the European Union to the Council of Europe and the European External Action Service. Leading the EU delegation at a challenging time for both organizations, as issues such as the rule of law crisis in some EU member states, and of course the war in Ukraine, featuring high both on the agenda of the Council of Europe and the European Union. Welcome and thank you very much, Ms. Ambassador, for accepting our invitation. Following that, we will turn to Professor Jurg Polakiewicz, Director of Legal Advice and Public International Law at Council of Europe. Professor Polakiewicz has been for a long time involved with various legal aspects of activities of Council of Europe, and it would be difficult to list them all. But perhaps of note, it's other, broadly speaking, legal aspects of relationships between the Council of Europe and its member countries, but also election of the judges of the European Court of Human Rights and several other items. And finally, our third guest today is Dr. Marcin Szwed from Helsinki Foundation for Human Rights. Despite the Finnish name, this is a very much a Polish non-governmental organization, one of the biggest and oldest and most important in the country, working on protecting and promoting human rights, democracy, and the rule of law at a very difficult time in Poland. Marcin has been personally involved in several cases before both European courts and brings much valuable experience from the NGO perspective to the table today. I would like to ask all our speakers to keep their cameras on throughout the event, but of course use the mute function when appropriate, and ask for our dear guests and attendees of the event. There will be a Q&A session at the end, so please use the Q&A function of Zoom or the event chat to present your questions throughout the event. We will collect them at the end, and with help of my colleagues here, we will try our best to forward those questions to the most appropriate speaker at hand. Once again, I would like to profoundly thank you all of us for joining today's event, and I would turn the microphone over to Ioana Ilescu from European Implementation Network to start introducing our report and its key contents.
Thank you, Jacob. I will share my screen in a second. Okay. So thank you all to all the participants for joining us today. I will share the findings of our report in relation to the non-implementation of judgments of the European Court of Human Rights. I should also mention that the report will be available on our website later today as well. Just try to move to the next slide. Okay. So first, I would like to explain why we look at non-implementation of the European Court's judgments as a rule of law issue, which is pertinent for the European Commission's rule of law report. There are two reasons for this. First, the judgments, particular judgments of the European Court are central to the rule of law. So they are judgments which concern serious problems with independence of the judiciary and impartiality of the judiciary, and also control of the executive on the judiciary. But also there are a range of judgments which concern the protection of fundamental values which are necessary for maintaining a democratic way of life. So these judgments cover issues such as the protection of free speech, freedom of assembly, and the need for a pluralistic media environment. So these judgments need to be implemented in order for these underlying freedoms to be protected. And the second reason is that the overall ECHR implementation is intrinsically a rule of law issue. So court rulings are emblematic for governments which are run by laws and which are run by a system of checks and balances rather than the absolute power of government. So as long as these judgments can be ignored, then we do not have a rule of law. A few words about our methodology and our key data. So in terms of the data in this report, it is accurate as of the 1st of January 2023. The number of pending leading judgments in this report has been taken from the Council of Europe's 2022 annual report for the supervision of judgments and decisions of the European Court of Human Rights. And the other data points have been calculated using the data from the Council of Europe HUDOC exec database. So we use three key data sets for this methodology. First, we look at the number of leading judgments which are unimplemented. We look only at leading judgments, but not at the overall number of judgments, because leading judgments are those which present new structural or systemic human rights issues. So we see that at the European Union level, there are 616 leading judgments pending implementation, or which are not yet implemented. The second key data point that we look at is the percentage of leading cases which have not been implemented from the last 10 years. So we look at the percentage from the last 10 years because different states joined the convention system at different points in time, and this helps us compare the situation in different states in an effective way. And we see that for the percentage of the last 10 years of leading cases which are not implemented in EU states, that number is 40%. And finally, the last key data point or the last key metric that we use is the average time that leading cases have been pending implementation. And for EU states, that is 5 years and 1 month. So you will see in our report that we have a color-coded classification for the overall record of implementation of EU states. This map is in the report. So we'll see what the situation is like in different EU countries. Some states are doing really well in terms of implementation, like Luxembourg and Austria, Denmark, the Netherlands, Sweden, the Czech Republic, and Latvia. However, more than half of the EU states have at least 10 leading judgments which are not implemented, so 10 human rights, systemic or structural problems. Furthermore, we note that 5 countries in particular have very poor implementation records. So those are Hungary, Poland, Romania, Bulgaria, and Italy, as all of these countries have over 30 leading cases pending implementation, or much more than 30. 4 of these countries, so Hungary, Poland, Romania, and Bulgaria, have leading judgments which are unimplemented, which concern independence and impartiality of the judiciary. In terms of numbers, the highest numbers of non-implemented judgments we see in Romania and in Bulgaria, with over 90 leading judgments pending in each country. Romania has 113 judgments. In terms of percentage of not implemented judgments from the last 10 years, Hungary has the highest percentage of non-implemented judgments from the last 10 years, standing at 76%. And in terms of the average time for which cases have been pending, we see that in Finland, although it has quite a low number of judgments which are not implemented, they have been pending for a really long time. So it has the highest average time in the European Union, which is almost 13 years. So finally, in comparison with the previous year, we see that there has been a slight increase for all of the 3 key data points. So above, you will see the graph for 2022 and below the graph for 2021. So what we see here is that the number of pending leading judgments, the percentage of pending leading judgments from the last 10 years, as well as the average time, they all have slightly increased, which for us means that the court is delivering judgments faster than the states are implementing them. Just to wrap up, you will see that this report contains country pages on all 27 EU states. So for each country, there is the breakdown of these statistics, as well as a short commentary of the overall situation and some examples of human rights issues which remain unresolved in these states. They are ECHR implementation problems in almost every state, and we express particular concerns for those which have very poor implementation records, and also those which have rule of judgments which concern rule of law issues such as independence and impartiality of the judiciary. And we believe the urgent action is needed to promote systemic solutions to these human rights problems. Thank you.
Thank you very much, Joanna, for presenting the European Court of Human Rights side of things. And now we will turn to the second component of our report, which is a look at the situation with regards to judgments and decisions of the Court of Justice of the European Union. One additional word here, I'd like to take the opportunity to thank the good lobby profs, and in particular Professor Laurent Pech, for helping us with developing the methodology of this part of the report. While both courts are not directly comparable due to the differences in their nature and the role they play in their respective legal systems, we've reached out to national experts in 19 EU member states, and in particular those countries where we know that the situation is difficult for one reason or another, to look into what are the issues with respecting the decisions of the Luxembourg Court. But for the details, I'll now turn over to Dr. Nina Tsereteli, our research officer.
I'm sharing my screen. I believe it's visible. So as Jakub mentioned, we focus on the CGEU side of things. So we have studied the rule of law related rulings of the CGEU, particularly in the areas covered by the Commission's rule of law report. We have studied and tried to capture a broader range of state responses between from complete inaction by the states to full compliance. So we tried to track different types and levels of non-compliance. With regard to each state we looked at political and judicial responses, and we looked at legislative amendments as well as implementation where possible. However, in some of the instances, some of the legislative changes are rather new and further follow-up is needed. As Jakub mentioned, we contacted national experts and covered 19 countries for this report. Unsurprisingly, the 2 countries that stand out in terms of the highest number of rulings on the rule of law and the worst and most problematic rule of law and implementation record are Poland and Hungary. However, experts highlighted also significant issues in Romania and Bulgaria. And now I move to our findings. We identified 4 types of non-compliance, and the examples for each of these types is given in the report. Sham or facade reforms or more cosmetic reforms, partial or incomplete implementation, especially when the reforms address only some of the elements of broader systemic problems. The third is the protracted rule of law processes, where they last years and years without any tangible progress, and finally complete inaction. One example, just to give you, comes from Poland: replacement of the disciplinary chamber of the Supreme Court with the professional liabilities chamber in line with the in order to implement, presumably, the CGU ruling, is one example of the sham reforms, we believe, because the new chamber retained many of the problematic aspects of its predecessor, in a sense of having new judges appointed with the involvement of the politically appointed Judicial Council, which remains in place, and this situation remains further follow-up, especially in view of some of the more recent legislative proposals from December 2022, which intends to move the disciplinary proceedings for judges out of the Supreme Court into the Supreme Administrative Court, I believe. But these changes have been blocked by President Duda and moved to the Polish Constitutional Tribunal. Most recently, the CGU found another violation in connection with the muzzle law. It came rather late in view of condemning the disciplinary chamber, but still very important, and it's quite telling that after the judgment, the Ministry of Justice made rather critical comments, and kind of it signals the likely lack of respect for this verdict. So this is one of the situations that will be further following up. However, it doesn't seem very optimistic in terms of and promising in terms of implementing the judgments. For example, with respect to the partial or incomplete implementation, we see debates in Hungary and Romania regarding the sufficiency of the proposed or implemented changes, particularly in terms of whether proposed changes would help remove the obstacles to the national judges' use of the preliminary reference procedure or generally application of the EU law. For example, with the Romania, we saw the abolishment of the disciplinary sanctions for non-compliance with constitutional courts, but it remains to be seen how the Romanian Constitutional Court will follow up and whether it will revise its approach. One of the areas which will be focused on is the Constitutional Court's practices and contestation, and we found several Constitutional Court rulings that are problematic in this respect. However, in view of within this broader trend, we see some differences between countries and constitutional courts. On the one hand, differences between constitutional courts that are independent, as in Germany, and challenge the CGU authority, and the ones that are captured and orchestrated by the government, as in Poland. On the one hand, we have more isolated instances of contestation. On the other hand, we have more systemic, essentially a string of judgments with which the Constitutional Court tries to counter emergent CGU jurisprudence. Other scenarios that are of interest are, for example, Hungarian Constitutional Court's practice on the case that was initiated by the government, where it avoided direct confrontation with the CGU, but essentially allowed non-compliance under conditions that the government would determine. And finally, the Romanian Constitutional Court that essentially precluded national judges from applying the EU law and still hasn't revised its approach, at least at the time our questionnaires were filled in. Finally, we have looked at the formal and informal barriers that the national judges face in submitting the reference requests for preliminary rulings to the CGEU. We see in several countries some of the formal barriers, such as, for example, the possibility of having the request blocked and declared unlawful or irrelevant to the dispute at hand. However, we also see a broad range of informal barriers, two categories. In one category, we see some of the harassments and threats towards judges, especially in countries which also have or had formal barriers to the submission of requests, but also in a much broader range of countries. We have challenges in terms of complexity of the procedure, time and resource constraints that judiciaries are subject to. In some countries, some more cultural, so-called cultural arguments in terms of reluctance to apply the EU law, etc. Out of our research, a few messages emerge towards the Commission, European Commission, in terms of using various tools available consistently across countries and issues and in a timely fashion, and the need to pay attention to various problematic reforms like sham reforms or partial and fragmented reforms, and to avoid premature approval of proposed reforms whereby the Commission would then block any further efforts at the domestic level in terms of securing further improvement and change. And finally, in terms of making difference between scenarios where the governments instrumentalize the laws, which is the case, for example, very much in Hungary, and scenarios where the laws seem adequate, but then there's this major issue in terms of informal power in certain areas. Finally, I will finish with several recommendations, joint recommendations that we prepared together with the EIN and directed at the EU. The recommendation, there are four of them. The first recommendation focuses on the annual rule of law report of the Commission. For the first time last year, the Commission essentially integrated and acknowledged the overall levels of implementation of the European Court's leading judgments as a rule of law issue. It's a welcome development, and we call for maintaining this approach and incorporating this data, but at the same time zooming more on the rule of law related CGU rulings as well, especially where this involves countries that have a high number of rulings of this kind, and if there are significant delays. Also within this recommendation, we believe that annual rule of law report should also include specific recommendations as regard to the states with particularly alarming overall record of the implementation of ECTHR rulings, and states that have also unimplemented rulings from both courts within the area of the rule of law, more narrowly defined, and particularly the independence and impartiality of the judiciary. The report gives specific list of such rulings. In the second recommendation, we call for consistent use of other tools available to tackle systemic failures to implement reforms in line with the judgments of the two European courts. This includes some of the descriptive tools like the EU Justice Scoreboard, but also financial tools. And the main underlying message is to make sure that the Commission doesn't accept inadequate reforms of compliance. In our third recommendation, we believe that the EU institutions should raise the issue of non-implementation of the European Court rulings bilaterally in their engagements with the member states, governments and national parliaments in an impactful way to engage and encourage compliance. And finally, we call for the dedicated EU funding for civil society, particular calls for proposals that are specifically designated to support civil society in its work on promoting better implementation, monitoring, assessment, participation and supervision of implementation, etc. And finally, we would call for also EU funding for Council of Europe activities aimed to support better implementation of ECTHR rulings. I guess my presentation stops here. Thank you for your attention.
Thank you very much, Nino. And now I will turn to our esteemed guests. But first of all, a reminder to all in the audience that we're waiting for your questions using the Q&A function or the chat if you feel like some of the aspects that were discussed warrant expansion, please let us know. And now I will turn over the mic to Ms. Ambassador Vesna Kos for her intervention.
Thank you very much indeed, Mr. Rachevsky. Good afternoon to everyone. As you have mentioned in introductory remarks, I am head of the EU delegation in Strasbourg, and indeed these are very challenging times when it comes to the work in general of the European international, if we will say like this, architecture. So I'm really happy to speak on the cooperation between Council of Europe and European Union, in which is so close and so developed that we call it strategic. However, I will focus now in my introductory remarks on the draft report that we have received, and that, as we see, contains also a number of recommendations addressed directly to the Commission, other institutions, and the European Union itself. And of course, afterwards, if there is an interest, I'm happy to address the issue of the cooperation between two organizations, including in respect of the war in Ukraine. That certainly is more my area of expertise than the one that I will now address in the introductory remarks related to the report. But I would like to thank you for invitation. I would like to thank you for the report, to co-authors for indeed timely report that will be very useful for us as European Union as well. And I will have few remarks on your findings. First of all, I would like to underline that we also recognize the importance of this issue as a rule of law issue. What is demonstrated by the standing case law of the European Court of Human Rights, and according to which the execution of the judgment given by any court must be regarded as an integral part of the right to fair trial under Article 6 of the ECHR, and it follows that this is also the case under Article 47 of the Charter of Fundamental Rights of the European Union. And in recognizing the importance of this topic, as was mentioned already, last year's rule of law report has for the first time included an overview of the implementation of the judgments of the European Court of Human Rights for member states. The 2023 rule of law report is planned for adoption this week on Wednesday, on the 5th of July. And the European Commission is looking forward to again discuss the findings of the rule of law report in the Council with the member states, as well as with the national parliaments to address the third recommendation, the European Parliament, citizens, and civil society. Second point, we note that the draft report contains several recommendations addressed to the European Commission. We would also add that also the courts concerned themselves have an important role to play, and we would not exclude indeed that the failure to execute the judgment of the ECHR or to comply with the judgment of the Court of Justice of the EU would be considered by either of these courts to constitute a violation, respectively of Article 6 of ECHR or Article 47 of the Charter. Looking at rule of law issues more broadly, when it comes to the European Union rule of law toolbox, we have over past years continuously expanded it with new tools, such as the rule of law report with country-specific recommendations, milestones related to justice systems in the member states' recovery and resilience plans, or the conditionality regulation. And we have been putting each of these tools to use in accordance with their specific objective, and where appropriate, you have seen that we have not shied away from launching infringement procedures. Third point, as the European Commission is as the guardian of the treaties, is committed to make full use of the applicable procedures to ensure that the judgments of the Court of Justice of the European Union are complied with. And as you know, the Charter of Fundamental Rights is binding on the European Union and its member states when they implement EU law. And to the extent that the Charter contains rights which correspond to rights guaranteed by the Convention, the meaning and scope of those rights shall be the same. As it follows from that fact, that the compliance, from this it follows that compliance with judgment of the Court of Justice of the EU may indeed incidentally also overlap with the execution of a judgment of the European Court of Human Rights and vice versa. And we would like to thank the co-authors of this draft report for the useful information it contains in this respect that will assist the Commission to execute its role. Fourth, this is already so today, but we can also look a little bit into the future. And as stated by President Juncker and First Vice President Timmermans at the time when the negotiations of the EU's accession to the European Convention on Human Rights were at their resumption point. So they addressed a letter to the Secretary General saying that the European Union's accession to the ECHR will reinforce our common values and the coherence of fundamental rights protection in Europe. And this will enable us to achieve our common goal of strengthening the pan-European system of fundamental rights protection. And with the improvement, well, with the advancements, if we can say, in this process in last year, in particular, the provisional agreement on the European Union's accession to the ECHR, almost all the problems that had to be addressed to make EU accession to the ECHR possible have been tackled, and we believe that this is a good advancement and good news both for the European Union and for the Council of Europe. And finally, a remark on the financial resources, or the call for the European Union, recommendation to the European Union to make available financial resources to the Council of Europe, including for the court system. European Union as the observer, we don't have the membership status in the Council of Europe. That doesn't allow us to contribute to the regular budget. We do contribute to the programs and projects, and the European Union is by far the biggest donor in this respect, and we finance indeed very significantly the third pillar of the organization. When it comes to the financial contributions to the court activities, the European Union will contribute financially to the work of the European Court when it accedes to the European Convention. This will be a significant contribution that is also agreed in the accession agreement. And by then, as Reykjavik Declaration from the Fourth Summit is providing, the member states, the heads of states of governments of the member states of the Council of Europe declared that they will ensure that the Council of Europe and especially the European Court of Human Rights will be financially sustainable. Thank you very much.
Thank you very much, Ms. Ambassadors, for those observations from the European Union point of view. And now I will invite Professor Jörg Polakiewicz to present the Council of Europe side of things.
Yes, thank you, Jakob, and it's a real pleasure to be with you in this webinar. And I very much thank the organizers for having invited me. Just on my person, very briefly, I'm, despite my Polish name, I'm actually a Berliner from Germany with some Polish ancestry. And but I'm certainly not, I don't speak Polish, and I'm certainly not an expert on Polish law. I should also stress that at the Council of Europe, I'm the head of the legal service. I have, despite having made a PhD on the execution of judgments, I personally never worked in either the court or the Department of Execution. But I'm regularly consulted, of course, the legal service, my colleagues and myself, we are regularly consulted also on issues relating to execution. For example, the use of infringement proceedings or the consequences of Russia's exclusion from the Council of Europe, or issues arising under the rules of procedure. However, I should stress I cannot speak about these legal opinions since they are confidential, nor can I divulge any thing that is said in the Committee of Ministers, which were the meetings that are dedicated to supervision are held in camera. And also any views I express are personal. This I must say because of my status. After this caveat, I really want wholeheartedly congratulate you for the report. I think it's a very rich report and an impressive work. As you say, you used very intelligently the data that the Council of Europe provides on these issues. And I will later come to a few comments from exactly on the report and the recommendations. But before, I wanted briefly to give very briefly the sort of the legal context of execution in a few words, and also what was mentioned by Ambassador Vesna already, the Reykjavik summit, which had a focus also on the implementation of judgments. And for the very briefly on the legal context, you must understand that the court judgments, the implementation is, of course, the primary responsibility of member states. And the court as such gives very often that its judgments importance indications of how certain judgments should be indicated. But in the vast majority of cases, it just finds a violation, and then it is left up to the member states to implement under the supervision of the Committee of Ministers, which is the primary organ when it comes to implementation. As the court has said it in an important judgment, Mamadov, in the Mamadov infringement proceedings judgment, it said the committee is the executive body of the Council of Europe, and as such, its work is a political character. That said, when supervising the execution of judgments, it is fulfilling a particular task, which consists of applying the relevant legal rules. And in fact, this tension between being a political organ supervising judicial decisions in the past, distant past, sometimes it was said the Committee of Ministers was maybe not always very strict. But I think this has really changed. We have now quite a comprehensive process thanks to the Department of Execution that prepares the notes and all the documents for the meetings. It is a collective responsibility of all 46 member states. And in the end, it's also noteworthy to say that most decisions, the proceedings are really characterized by consensus. The committee, in most cases, most decisions, even those that find non-implementation or slow implementation or criticize the government, they are usually taken, including the vote of the respondent states, or practically no vote is taken, simply the consensus is established. And I think this is very much expresses this idea of collective responsibility in the field. The EU, as the ambassador said, it is not, for the time being, it is already a participant in the proceedings, but without the right to vote or to table amendments. Now I come to the Reykjavik summit, which was just held in May, and in fact it had a focus on execution. There's a whole, apart from the main declaration, there is an appendix on recommitting to the convention system as the cornerstone of the Council of Europe's protection of human rights. And there you find the kind of roadmap or indications of the future work that now the Committee of Ministers has to implement in the coming month. And when you read, I cannot, of course, I will only give a short introduction. I'm happy to respond to questions. You will see the focus is very much on the one hand, of course, full implementation is stressed, and rightly so, as a cornerstone, as you also say, of the rule of law, but the obligations of states under the convention. And it is said, it is also recalled, but I think that's also important to recall, that the large majority of judgments are in fact fully implemented. Sometimes it takes time, but usually there is a relatively good record of implementation, which you find in the annual reports on execution. And if there are problems encountered, very often they are simply due to limited resources or technical expertise. Hence, one lesson or one instruction from the summit is to increase, what you also say in your report, increase cooperation activities with the states concerned to help them overcome difficulties and give them technical advice. And also very important, the role of NGOs and national human rights institutions, which are, if you want, the ears and eyes also for the Council of Europe. We are present in some countries, but not in many. And so the input from NGOs and national human rights institutions, which make submissions directly to the execution process, is crucial and very important. And the system has benefited a lot over the years. I remember when I did my PhD now 30 years ago, basically nothing was public. I had to come to Strasbourg, and even in Strasbourg, almost nobody would like to tell me because everything was behind closed doors, no documents were published. This situation has completely changed, and it has allowed precisely this input from civil society and national human rights institutions. But the focus of this summit declaration is really on enhanced, cooperative and inclusive, but also a more political approach. There is also the awareness nowadays that you have, in certain cases that are politically sensitive, and I think these are the ones that you focus in your report, you have to involve also political decision makers. So the committee now invites regularly ministers of justice or state secretaries for a dialogue. Now, coming finally to your report, as I say, it is a very impressive report. I can fully subscribe personal view, of course, to your recommendations. I think, as you call it, factoring the issue of non-implementation into the relevant, into the EU annual law report is a very good idea. The Commission has already started doing this, and also special emphasis on independence and impartiality of the judiciary, which is a key issue. After all, we are witnessing a backsliding on rule of law in many countries. And what also coincides perfectly with the Reykjavik Declaration, also involving other bodies, actors, civil society, but also Council of Europe bodies like the Venice Commission. And I think what is quite interesting in all this context is the synergies between the two courts, the two European courts, or in Luxembourg there are not only, there's several courts, and the Strasbourg court, but this synergy between Luxembourg and Strasbourg, I think both courts have been really much more united than maybe they've been before in this common battle, if you want, combat for the rule of law. And the judgments are really mutually enriching themselves, and there are several cross-references. They are still maybe not always complete harmony of interpretation. Just to give you one example, in this recent court judgment for experts, C-204/21, Commission versus Poland, there is a reference to the Constitutional Court, but the Court of Justice limits the potential impact of the ruling by referring only to the principle of primacy, but does not mention the European Court of Human Rights judgment in Xeroflor, which found that panels of the Constitutional Court, which included persons unlawfully appointed, were not established by law under Article 6.1. And as I said, if lawyers, you can find still, despite union on the principal values, there are still sometimes different interpretations, and that's why also EU accession is so important to what the ambassador refers, because it can really be said that it realizes the principle of the rule of law. I would have some remarks, but I will maybe for time reasons not go very far on this, but just to mention it, where I do not entirely, fully agree with all the findings of your report is this issue of precedence, of sort of unconditional precedence of ECHR, EU law and constitutional identity. I think that this is a subject you can have a whole seminar on, and there will in fact be soon a conference organized by the Latvian presidency. I think this relationship, it's one of the most difficult but also interesting subjects nowadays, because you have really two sides. From international law side, of course, international law as precedents, EU lawyers will say EU law as precedent, but when you see it from the perspective of constitutional courts, it's not always so clear, because they, after all, argue from the constitution and say we have only transferred competences, or whatever it is called, powers to the courts in Europe in accordance with our constitution. So we must also be able to control whether these European courts respect these limits of sometimes called constitutional identity, sometimes ultra vires doctrine of the German court. But I think what is important in this context, so I would not say there should be also certain checks and balance after all for European courts. I think it would be, in my view, too one-sided to give a kind of total blanket primacy. There has to be also, that's why precisely the Court of Human Rights, for example, accepts margins of appreciations, because there can be certain degrees, and there must, after all, be room for national and constitutional identities. But of course, it has to be done, all these interpretations, on the basis of common values, and not in a way that undermines the independence of the judiciary, as has happened, for example, in Poland. And you have seen this is now very much, all the decisions are public. In the last Committee of Ministers, the H meeting, quite detailed decisions were adopted that really call on Poland to reform its so-called reforms of the judicial system in a way in line with both EU and Council of Europe law. But on the whole, I think the constitutional courts work together, and European courts. There is a nice saying, a falling tree makes more noise than a growing forest. I think there is, after all, a community of values of European and constitutional courts and dialogue which progress towards common goals. And the rare exceptions are cases where constitutional courts stop implementation, and it's really, but one should not this overestimated either. And a final word to conclude, I think, as I said, I personally can fully subscribe with your recommendations. And the EU should, in fact, join as soon as possible, as was said, the ECHR, but also other mechanisms like GRECO. This allows the EU to make full use of them when it comes to also country-specific interventions. And but on the other hand, also a note of caution. I think with this I will conclude. That's Professor von Bogdandi said this in very nice words. I think we must always be aware, as much as we from European level, we want, of course, to improve situations, but we should be aware, as he said, that to many people, European institutions appear distant and foreign if they urge or even try to force democratically elected governments to revise important political projects invoking European values. They run the risk of being rejected as self-important, arbitrary, and illegitimate actors. The same holds when other member states insist on values. So I think we must be also aware not to impose solutions from one country in another. And it is very important to credibly defend European values using fair procedures that convincingly show a broad European public what the values are, why they have been violated, and what needs to be done. In a nutshell, it's important that all European institutions speak on the same level, use the same terms, and use the same values, of course, and also to avoid forum shopping. But I think, as I say, on the whole, we have a difficult situation, but I think between the two institutions, the situation has vastly improved in the 30 years that I'm in the Council. I think we are now the most important strategic partners, and the war in Ukraine has even more underscored this need of unity, of democratic Europe versus Russia and Belarus. Thank you very much.
Thank you very much, Professor, for those comments. You spoke about the civil society as the eyes and ears of the Council of Europe and the human rights system. And we fortunately have an extremely capable pair of eyes and ears with us today. Dr. Szwed from Helsinki Foundation for Human Rights. I turn the mic over to you for your comments.
Good afternoon, everyone. Thank you very much for inviting me to this event, and I would like to congratulate the authors of the report. I fully support all the recommendations, in particular those concerning the higher involvement of the EU in terms of in the sphere of supervision over implementation of judgments of the court. In my short presentation, I will highlight the most important problems with the implementation of the European Court of Human Rights judgments in Poland. To some extent, also, I will refer to judgments of the Court of Justice of the European Union. I will also briefly discuss the problem of non-implementation of judgments in Hungary. I will rely here on information provided to us by our colleagues from Hungarian Helsinki Committee. So according to the report, Poland is one of the countries that have the biggest problems with the execution of the European Court of Human Rights judgments. 46 judgments remain unimplemented, and some of them remain unimplemented for many, many years. And the reasons of why they are unimplemented vary. I will separately discuss cases related to the ongoing rule of law crisis and other cases which are more related to some systemic problem that have existed in Poland for years. But first, I will say a few words about the second group of cases, those which concern problems which are related to some problems that have existed for many years, even before the Law and Justice Party came to power. And from my perspective as a lawyer of the human rights NGO, I think 4 problems here are the most important. So the first problem is the issue of lengthiness of court proceedings. There were many judgments of the European Court in this area: Rutkowski versus Poland, Beller versus Poland. And in the recent years, this problem has even grown more, which is, of course, connected to the general crisis around the Polish judiciary. The lack of enforcement of these rulings in this area is probably due to complexity of the problem of excessive length. So this problem of excessive length court proceedings is caused by many factors. Some of them are organizational, some of them are procedural, and its elimination will require a very thorough, comprehensive reforms. A second very important problem from the perspective of human rights NGOs, from the perspective of individuals, from the perspective of general lawyers in Poland, is the abuse of pretrial detention. There were many cases, for example, Burza versus Poland, which stated that Polish courts applied pretrial detention too easily. And the statistics show that nearly 90% of prosecutors' requests for pretrial detention, 95% of requests for extension of detention are granted by courts. And the recent opinion, Rule 9 submission, jointly submitted by the Helsinki Foundation, the Polish Bar Council, shows that very often courts' decisions on pretrial detention are not properly justified, and the courts do not sufficiently take into account constitutional and convention standards. So here we can underline that not only some legislative changes will be necessary, but also a change in the approach of courts, because implementation of judgments of courts is a duty that lies not only on government, but also on in some cases, at least on courts. A third problem relates to access to legal abortion. Here we had a case, for example, Tysiąc versus Poland, or P&S versus Poland. And this is yet another problem that Poland has been facing for years. And it is caused by many factors, in particular, overly restrictive laws, including criminal sanctions or invocation of the conscience clause by doctors. Recently, the problem around access to abortion even have deteriorated due to a judgment of the Constitutional Tribunal, which declared one of the grounds for legal abortion unconstitutional. And implementation of the judgments of the court in this area would require legislative changes, but of course, for political reasons, it is very highly unlikely that this will be done. And finally, criminalization of defamation. This problem is explicitly mentioned also in the report. In Poland, defamation is still a crime. There were many judgments of courts which found violation of Article 10 by Poland in this area, but unfortunately, this provision is still part of our criminal code. So some legal changes will be necessary, but also, once again, probably changes in the interpretation of law by Polish courts, which sometimes do not take into account the value of freedom of expression to a sufficient extent. And finally, I move to the problem of non-implementation of the judgments related to the rule of law crisis. So we can identify here three groups of cases. First, set of law versus Poland, which concern the crisis around the Constitutional Tribunal and participation in its work of unlawfully elected persons. Secondly, defective judicial appointments as a result of unconstitutional changes in the National Council of Judiciary, here Rzeczkowicz versus Poland, and a group of other cases, but also a jurisprudence of the Court of Justice of the European Union relates to this problem. Formal and informal instances of harassment against independent judges. Here we can mention Juszczyszyn versus Poland and Żurek versus Poland, but also judgments of the Court of Justice of the European Union, which found that Polish system of disciplinary responsibility of judges is deficient. There were also individual judgments concerning dismissal of presidents of courts in Poland and termination of the term of office of members of National Council of Judiciary. And all these judgments of the court remain under supervision of the Committee of Ministers. As Professor Polakiewicz already mentioned, recently the committee made some decisions concerning non-implementation of the judgments and recommended Polish authorities to take some steps, for example, to restore independence of the National Council of Judiciary, to regulate the status of unlawfully appointed judges, to ensure that unlawfully elected judges will participate in constitutional tribunal works, and so on and so on. Unfortunately, those recommendations have not been implemented yet, and there is no hope that the current authorities, political authorities, will implement them soon or at all. As is well known, the current government not only rejects the possibility of full implementation of these rulings, but also by initiating procedures before the Constitutional Tribunal openly undermines them, that undermines their validity and binding force. Thus, at present, judgments of the European Court of Human Rights in the sphere related to the rule of law are still unenforced. And the same, of course, concerns judgments of the Court of Justice of the European Union. There were some developments with regards to organization of the Supreme Court, some changes like the abolishing of the disciplinary chamber and some reorganization of the system of disciplinary responsibility of judges. However, none of this reform solves the main roots of the problem, that is the lack of independence of the NCJ, and unless the authorities restore the independence of the National Council of Judiciary and regulate and regularize the status of unlawfully appointed judges, we really cannot say about implementation of judgments. It is worth noting, however, that despite this lack of political will in Polish authorities to enforce the judgments of the court, the problem of necessity to restore the rule of law in Poland has been the subject of activities of various Polish NGOs, which have even recently published some 30 draft laws on how to implement the said ruling. So with regards to Constitutional Tribunal, we had a draft published by a Battery Foundation, and with regard to situation in courts, a project of the Polish Judges Association Justitia. And it's of course very good that these drafts have been created, because they start a discussion: how can we prepare for the restoration of the rule of law? How can we ensure that judgments of European courts will be finally implemented? Nevertheless, they will still have to be thoroughly analyzed in terms of their legal effects and compliance with the constitutional and international standards, because given the scale of changes under the law and justice government, the restoration of the rule of law in Poland will not be an easy task, and many difficult issues will have to be resolved. So, for example, with regards to Constitutional Tribunal, there is proposal to declare all of the judgments issued in defective formation as invalid. Nevertheless, the problem appears whether such solution will not threaten legal certainty, because some of these judgments were, in terms of their substance, obviously correct and led for some persons even to acquire some rights. For example, there was judgments concerning access to social benefits for persons who take care of persons with disabilities, and if you declare that judgment invalid, then the question appears: what will be effect on the person who have access who got access to such benefits on the basis of judgment of the tribunal. In the case of judges appointed at the request of the new NCJ, we also will have to consider whether simply removal them all by the virtue of law will be actually permissible under the Polish constitution or the international law. There is more than 2,000 of these judges, and according to the case law of Polish courts, not always their participation in proceedings of cases will lead to invalidity of proceedings. So these are just some exemplary questions that will have to be answered before we fully implement judgments of the court. And finally, I would like to say a few words about situation in Hungary. Hungary, according to the report, according to all of the available information, has a very poor record in terms of implementing the European Court judgments. Actually, it is the country with the highest percentage of unimplemented rulings at the moment, around 76%. And among unimplemented judgments, there are those which are related to the rule of law crisis in Hungary. There are, for example, cases concerning secret surveillance or limitation of freedom of expression of judgments, including case of Baka versus Hungary. The state of implementation of the CJEU judgments is also rather poor. Very often, judgments of CJEU are implemented at best only partially, like, for example, judgments concerning obstacles of Hungarian courts in submitting preliminary references to the CJEU. And according to the Hungarian Helsinki Committee, this problem of non-implementation of judgments of both European courts is linked to general threats to the rule of law in this country, but also to some general Hungarian infrastructure for the enforcement of this. Therefore, as we can see in both this, there are some systemic problems with implementation of judgments of European courts, and actually the situation is rather similar in both of these countries, and therefore both of them will have to undertake some systemic changes to fully implement the rule of law standards established on the European level. Thank you very much.
Thank you very much, Marcin. And we will now turn to the questions and answers. We remind our dear audience to submit their questions in the chat. But I would like to kick off with one question which came from several directions, but also speaks to curiosity of us at DRI and EIN. And this is a question which probably for most of you will be quite unexpected one. The ongoing process with the European Union negotiating with Council of Europe to become party to the European Convention of Human Rights has advanced recently. We had some public statements that gave us encouraging news as regards to the second attempt by the European Union to become a party to the convention. And this topic has been debated for long in academia and among NGOs. And I would like to ask all of our panelists on their perspectives for that happening and their reflections on the possibility of the European Union acceding to the convention, and also perhaps on some possible consequences of that for the topic which we are discussing, and that is strengthening the implementation of judgments of both courts. I think we will start in the order of our speakers. So, Ms. Ambassador, do you have any remarks on that topic?
Well, thank you very much for this question. I think that's from many perspectives, this is maybe the objective also of, let's say, my mandate here in Strasbourg. I think that is Of course, the obligation for the European Union that is stemming from the Lisbon Treaty, there's the process that is long ongoing, but that is also a process that approached a very important milestone by the fact that the provisional agreement was reached in Strasbourg, so that the negotiations provisionally between the European Union and other parties to the convention at this moment are accomplished. That depends of one unresolved issue that the European Union has defined as its internal issue, and that is up to the European Union member states to resolve in Brussels. Of course, we are looking forward to and lots of work on this has been done already by the presidency of Sweden, and we are looking to current presidency, Spanish presidency, and other presidencies to continue this work. But from the point of view of the institutions in Reykjavik as well, quite publicly, it was the statements were very strong, both by the President of the Commission and the President of the European Council, that there is a strong support that this happens as soon as possible. Of course, to these statements oblige the institutions to facilitate as much as possible the accomplishment of process in Brussels, but which is ultimately for the member states to accomplish. But we are hoping that this will be soon, and this is not beyond the realm of reality that, as it was, I think, mentioned as it was considered for a while. It's more realistic than before, I would say, but of course, as long as we don't have the final agreement, it is difficult to say that the process is accomplished already. Thank you.
Thank you very much, Ms. Ambassadors, for those reflections. And now I would ask Professor Polakiewicz if you have some remarks on this ongoing process and where it's headed.
Yeah. Well, thank you, Jakub. This is a bit the story of my life almost, when I hope I will see some concrete results before I retire. Yeah, it has been for the Council of Europe, of course, always a high priority, and as the ambassador said, it is an obligation even under the EU treaties. And I was really very happy that finally there has been a breakthrough. I mean, we were all frustrated in Strasbourg about this opinion 213 and the number of objections raised, but thanks to a very constructive dialogue and negotiations by the Commission on the one hand, but also the non-EU member states made big concessions. It was possible to basically come to a package on all objections except for one, the CFSP, the Common Foreign and Security Policy. And this was, I think it was really facilitated that we had this breakthrough in the last negotiation rounds. I think was due on the one end, I would say, due to the fact that Russia was excluded. It's no secret Russia was not making it easier, the negotiations. And on the other hand, I think also there was a pull factor push factor from the summit that one wanted to have a deliverable. In the end, it was not possible to completely finalize, but for the time being, the negotiations in Strasbourg have stopped, and we are waiting now for the outcome of the negotiations in Brussels between the member states and the Commission and Council and Parliament, but in particular Council and Commission. The CFSP is a very tricky issue. I think there will not be many. It will never concern many cases. It's really about these missions outside Europe, be the military or civil missions like in Mali or Somalia. So you can imagine, you can construct some cases that a pirate is detained by EU-led military contingents, and then transferred to a country where maybe he faces ill treatment or something like this. But this will never be many cases. But politically, the problem is politically it is very low in this, and then you have the complexity of EU law in this field of common foreign and security policy, the fact that the Court of Justice has only limited jurisdiction, and it's still a bit between it's still largely intergovernmental. So it makes it really a strange combination, and I understand, yeah, that it may take, it will not be tomorrow, but I think the European Union is working now in earnest to solve the issue. There's also an important case still pending regarding Kosovo, some ill treatment. I think a case where it is more or less clear that there is responsibility by EU authorities or institutions, but in fact no court declared itself competent, and both national courts have declined competence because it is the EU, and the EU court have declined competence because they have no jurisdiction under the treaties, and now an appeal is before the Court of Justice. And I understand that this outcome of this case must also be waited for to finalize the solution at EU level. But I think this, in the end, it's political will, as always in these fields. And from the summit, a very strong message was given in favor of accession. So I hope that this will come quite soon. And the importance, I think, is what you said, the consequences, just one word. The problem now is that we have cases, be it an asylum seeker in a refugee camp in Greece, or be it a criminal suspect who faces surrender extradition to a country where she or he may face inhuman treatment. These cases, they are now judged by, they can come under the charter, they come under the convention, but at this moment, although both courts, of course, have a dialogue, but there is no clear line what to do, where there is sort of both courts decide the cases, and the answer cannot depend. This is not the rule of law if the answer depends on which court the case goes. So it is important to have this also institutional links through accession. Dialogue is good, but I always say dialogue, courts normally speak through their judgments. And so there has to be this institutional link to have legal coherence and certainty. Thank you.
Thank you very much, Professor. And I think that a lot of people in this event hope that the story of your life will be happily concluded soon. But now I'd like to turn to Dr. Schwed, Marcin, from the perspective of someone who is working on the ground in the country, with both courts are issuing multiple judgments. How do you see the potential consequences and impact of the European Union acceding to the convention?
Yeah, this is a very interesting question. I'm not sure if I have a good answer, because I think these consequences will be very complicated, and we will see in the future what will be the interactions between both two courts, and how will, for example, case law of the European Court maybe affect even not only jurisprudence of the Court of Justice, but even some internal structure of the European Union. As we know, rulings of the European Court of Human Rights somehow necessitated to introduce some constitutional reforms on the domestic level. So maybe there will be some necessity to make some changes also on the EU level. I think that also another problem, very interesting, could be that after accession of the EU to the Court of Justice, to the Convention, maybe also EU bodies will be more willing to engage more in this supervision of implementation of judgments, as was suggested in the recommended in the report. Maybe even a commission will try to, for example, start some infringement proceedings if the state systematically violates its obligation to implement judgments of the European Court. But from the perspective of me as a lawyer of the Helsinki Foundation, it will be very interesting to identify the potential, for example, cases in which we could litigate against the European Union. At the moment, I think this will be very difficult for me to say in which circumstances we could even initiate proceedings against the European Union. But I think if this accession really takes place, probably some NGOs on the European Union level will try to start such strategic litigation.
Thank you very much, Marcin. And indeed, the issue of strategic litigation would be very interesting if the European Union was to accede to the convention. I now have a multiple group of questions, which I think can be best summarized. And also, once again, this will be a question probably to all the three panelists, is how can the cooperation between both organizations, Council of Europe and the European Union, be strengthened in the various forms that this cooperation takes? We have multiple interfaces between Council of Europe and the European Union. We have the institutional dialogue between the Committee of Ministers and the European Union. We have the joint programs, which are very close to my heart, as I spent quite a lot of time researching them a while ago, and where the European Union and the Council of Europe cooperate to implement capacity building and strengthening programs in both in Europe and outside of it. And so we have multiple interfaces, but we also have possibly some unexplored possibilities. And I would now turn to all our three panelists in the usual order to reflect maybe on how could the cooperation between both organizations be strengthened and what avenues for this cooperation they see. Ms. Ambassador.
Thank you very much for the question that is a little bit broader. So I think we can approach it from many different perspectives, but I would like to start by saying that indeed, I think that the cooperation is already very, very close. A strategic cooperation mainly in three areas. The one is a classical political cooperation. As you said, there is dialogue, there is the European Union delegation is part of the, well, we are sitting in the Committee of Ministers observing the procedures. We have insight in quite a number of groups and dealings of the Council of Europe. There is there are a few institutional forms of the dialogues that maybe were dormant for some times, but that are to be re-established, such as senior officials meetings that haven't been operational for a number of years, but we are expecting that we will have them restarted somewhere in autumn. But also the everyday cooperation, I would say, between the experts in respect of the joint programs, but in respect, the second pillar, big pillar of cooperation, which is legal cooperation, is of course not only with the ECHR, but also with the complete body of the standards that the Council of Europe has, and Council of Europe, of course, is a huge standard-setting authority in Europe when it comes to human rights, democracy, rule of law. Considering that two organizations share the same values, that both organizations legislate in similar areas, both organizations, of course, are looking into the new challenges, such as, for example, artificial intelligence. It is extremely important that this legal cooperation is very strong, so that what is done at the European level, again, considering that all Council of Europe, the European Union member states, and also member states of the Council of Europe, that this is done in 100% of complementarity and coherence. So political cooperation, the legal cooperation, and the third one, this is the area of programs that are indeed very, this is a widespread cooperation where European Union is the biggest, not only the biggest donor, but I mean, this is a cooperation that goes both sides. We, as European Union, rely a lot on the Council of Europe work in the field, for example, when it comes to our enlargement process, and we use Council of Europe's findings extensively into our enlargement reports. And then we also, of course, we mentioned already how far the influence of the Council of Europe monitoring bodies is for the rule of law report, not only when it comes to the jurisprudence of the European Court for Human Rights, but also when it comes to the Venice Commission practice, Greco, and others. And of course, European Union, I think that you mentioned the European Union needs to continue and join more and more the conventions of the Council of Europe. This is what is, I think, a final ambition, and as a good progress or good example in this respect, I would mention that just last week the European Union joined the Istanbul Convention and handed in the ratification instruments by the Swedish presidency, and the Commissioner Dali handed in the ratification instruments last Thursday. So this is another example of the European Union indeed working very, very closely with the Council of Europe to use our tools and our capacities in the best possible and complementary manner in creating a coherent legal space in Europe. Thank you.
Thank you very much, Ambassador, and I very much agree that the cooperation between Council of Europe and the European Union is a success story as far as collaboration between two international organizations goes, but also, especially in those tough times, there is never something that is as good that could not be improved in some way. And so I turn to Professor Polakiewicz for your reflections, or perhaps what else and what more could be done to strengthen the link between the two organizations.
Yeah, I fully concur that this is a success story, and in fact, yeah, it has really been transformed from a purely sort of technical cooperation into really strategic partnership. And with the war, the aggression against Ukraine, I think this has even reinforced the need, because now also you must simply look at the map now with Ukraine and Moldova being candidate countries to the EU. There is an almost complete overlap between the Council of Europe member states and the European Union. If you include candidate and associated countries, or countries that are bound to the EU by Schengen and other schemes, then you can even include Switzerland, Norway. So the end remain outside just Turkey on the one end, and Brexit, thanks to Brexit, the UK on the other side. So it is really important to avoid unnecessary duplications of mechanisms, and to bring the Union into the also the existing mechanisms of the Council of Europe. And as Ambassador said, recently we had also there important steps forward. The accession to the Istanbul Convention is a milestone in the sense that it was even done for the first time that the Union joins the treaty, and where not all member states are parties to. It's really an achievement of also the Swedish and before Czech presidency. So I think a lot has been done. I think the advantage, in fact, it's a bit maybe paradoxical, but I think the advantage of the Council, of course, the European Union has the political power and the clout, but the Council of Europe compared is a much less important political actor. But paradoxically, the fact of being not such a political actor, I think, makes the Council more credible when it comes to providing advice, like the Venice Commission does, or Greco making evaluations of the corruption in countries. Being not a political actor makes the Council more credible when it comes to monitoring and more on legal and according to legal parameters. Where there can be still improvement, I think, is a bit the institutional side, which remains a bit in a gray area, if you want, because what is funny that the European Union, though being the most important strategic actor, has not a very clearly defined role in the Council of Europe. As I said before, the European Union ambassador sits in the Committee of Ministers and speaks, but formally speaking, there are no voting rights. The I say often our legal framework, now I speak Council of Europe legal framework, still does not really reflect the realities post-Lisbon that the member states have transferred so much competences to the union. In the Code of Ministers, it's still only the member states that vote, for example, and although on many issues nowadays it is the European Union that is competent. At this we see also negotiations of conventions. And it is also a thing, and there's also one important point which came up also in the accession negotiations. There's also a sort of tension in the fact once the European Union is competent, there is the problem that experts from member states may no longer be entitled even to independently negotiate, for example, treaty. Because the Commission has a negotiating mandate, which is normal under the Lisbon Treaty. But this fact that the Council of Europe, after all, compared to the Union, is a small organization. We are a very tiny secretariat compared to the European Commission. And we rely on the input of national experts in negotiations, the same way in monitoring mechanisms when it comes to decisions by committees of the parties, for example. And there are some still challenges and to be overcome, because the combination that the EU is such a federated bloc, and at the same time, the member states are still, in most cases, so far at least, are still parties to all the conventions, sit in the Committee of Ministers, and we need also their active input. There are still, I can tell you as legal advisor, there are still unresolved legal issues, which surfaced also the accession negotiations, where it was necessary to formulate very complicated voting rules to avoid the result that the EU, simply by the sheer number of member states in the Council of Europe, would dominate, at least on certain procedures and decisions against the EU, would basically dominate the procedures unless you foresee special voting rules. So there are still issues to be resolved. There's a lot to be done for lawyers, but as I say, we are paid to find solutions, not to create problems. And the political will, I think, is certainly there. And what we need, I think, is a bit of more flexibility on all sides. Sometimes positions are maybe too rigid in certain areas, but I think the political will is definitely there, as the summit has shown, and I think we can only be reinforced. This is the only way forward in Europe, to work together.
Thank you very much. And I will now turn over to Marcin with the caveat that we're very much close to running to our close time. So please share your thoughts on the possible strengthening of the cooperation.
Yes, just a few words, because it's difficult to add anything after such comprehensive answers. So I'll just mention two issues related to implementation of judgments of the court, or even more broadly, implementation of the standards developed in the jurisprudence of courts. So first, I think that, for example, the European Commission could use more often the infringement proceedings to compel the state to implement judgments of the European Court. In this, of course, only in these cases, which also involves the EU law. So, for example, recently the European Commission started some proceedings against Poland in the case of anti-Russian commission, so to say. But of course, there are also other spheres in which such procedures could be used, like, for example, concerning the politicization of the National Council of Judiciary. And maybe if we analyze the jurisprudence of the European Court of Human thoroughly, maybe we could identify more judgments which lack of implementation would violate both the European Convention and the EU law, and in which EU bodies could use their competences more often. And secondly, I think that maybe also some legislative actions on the part of the EU could help the state or could compel the state to harmonize the law and to eliminate some systemic problems. So I mentioned to you in my short presentation, Poland had a big problem with abuse of pretrial detention. This is a problem not only in Poland, but in many other countries. So maybe, for example, it's a time for the EU to adopt a directive or other act of secondary EU law to harmonize these standards, take into account also case law of the European Court of Human Rights. And this is just an example. We could probably identify many other areas in which such harmonization of law could contribute both to implementation of the European Court of Standards and to increase the level of human rights protection on the EU level.
Thank you very much. And for the last moments of our webinar, we have actually a suggestion regarding our report coming from audience, and another familiar place of Mr. Andrzej Drzemczewski, suggesting an inclusion in the future report indication of states that have declared that they will not abide by interim measures of the Strasbourg Court. This is a very interesting suggestion. We have not been tracking this directly in the report. And also slightly impacting on that, this also speaks to the interim orders of the Court of Justice of the European Union. We have seen the long story of Poland not respecting an interim measure in the case C-204/21, which was mentioned today already. And Mr. Drzemczewski's suggestion is very sound, and perhaps one thing as last act of our webinar, a question if any of our panelists has thoughts whether this is a good idea to expand our report to cover also the interim orders and measures of both courts and respect toward those. I see some nodding with regards to that, but I'm not hearing any direct responses. So I will take it as a good sign and something that we will take forward while working on the next year's edition of this report. And with that, as we've already slightly run over our allocated time, I would like to thank you all, the panelists, for joining us today. I would like to thank the co-authors of the report for presenting the content, and all of people who join us in the audience listening to this presentation. We have posted the link to the report in the chat earlier, but you can also find it on our websites, and we will be making sure that you know where you'll find it in the coming days. And for much more on both implementation of European Court judgments, but also the rule of law in the European Union in general, please follow Democracy Reporting International and the European Implementation Network for our work in these areas. Once again, all of you, thank you very much for joining us today, and looking forward to more collaboration and to presenting next year's edition of the report as well.